Hi everyone, my name is Kartima Teka, and today I'm going to be talking about Dobbs versus Jackson Women's Health Organization. This case is a very recent case, and it happened throughout 2021 and 2022 in the Supreme Court, and it's about abortion rights, which is something that I'm really passionate about. So getting to the facts of the case was brought about in 2018 when the Mississippi State Legislature passed the Gestational Age Act, prohibiting all abortions after 15 weeks of pregnancy. And the reason that 15 weeks of pregnancy is really important and that Roe v. Wade had established that abortions could be banned after the 15-week period is because it's the fetal viability period, which means that the fetus can either survive outside the womb, and that's typically around 15 to 24 weeks in most pregnancies. So the Jackson Women's Health Organization then filed a case in federal suit court against this, as it was the only licensed abortion clinic in Mississippi on the very day that the act was about to go in place. Both district and U.S. Court of Appeals for the Fifth Circuit deemed that it was unacceptable due to the very short amount of time before viability, but Dobbs, representing the Mississippi State Health Department, petitioned to the Supreme Court. So when the case got to court, the constitutional question here was, is Mississippi's law banning nearly all abortions after 15 weeks gestational age unconstitutional? Arguments on either sides from the petitioners, they mainly said that the Constitution does not explicitly provide a right to abortions, and therefore the abortion ban by Mississippi was justifiable. Abortion bans were also not present at the time that the 14th Amendment was passed, and therefore they didn't protect abortion bans. Freedom applies differently to one's individual life rather than when another life is involved, such as a fetus. And that was an argument that I particularly found interesting, is how the 14th Amendment could be, manipulated in its interpretation when another life was involved. The respondents, on the other hand, argued that the right to liberty and personal happiness is implied in the protection of abortions, as it has to do with one's physical well-being. They also said that it's necessary for female independence and autonomy, and it allows women to have a lot of economic and social privilege since Roe v. Wade was passed. And they did mention that it will propel women backwards, and it's discriminatory to the female body since abortions were not a thing at the time of the 14th Amendment. The court ruling was in a 6-3 majority. The court ruled that the Constitution does not guarantee the right to abortion, and therefore can left to the democratic process or individual states to determine their state laws regarding abortion. Obviously, there was a lot of outrage about this, and anybody can probably remember from the very recent news headlines that would occur about it. It's been about a year since this court ruling was passed. So the opinions and dissents here from the majority, they mainly said that abortion is not in the Constitution, and therefore that it can be left up to the states, and that there's no justifiable reason to not allow pre-viability bans, and it can be left up to the medical professionals and the legislature of the state. The dissent, on the other hand, which was by Breyer, Sotomayor, and Kagan, said that women deserve autonomy over their bodies, and that, as I mentioned earlier, that abortion was not present at the time of the 14th Amendment, so therefore it cannot be interpreted to not apply to abortion, since the whole process of abortion was not even a thing at the time that the 14th Amendment was passed, and that since men passed the 14th Amendment, they were not thinking of a female abortion or of the future of female reproductive rights. The aftermath of this court ruling, obviously a lot of protests around the nation, as I mentioned before, and a lot of worldwide social media coverage on American laws. Also, this allowed states to, as I mentioned, choose their abortion ban legislation individually, and that led to many states banning abortion at 6 or 15 weeks. It also pushed the innovation and spread of other abortion methods, such as abortion pills and online services that help women. Women have also physically traveled or relocated from their resident states to obtain an abortion, and a lot of illegal abortion clinics have been operating in the states where abortion laws were refined. Thank you so much for listening to my presentation today, and I hope you had a great time.